Welcome to this special deep dive, which we've put together just for you, the learner.
That's right.
Today, we're tackling a really core concept in equity and trusts law, the constitution of trusts. It's fundamental stuff.
Absolutely. It underpins so much.
And we should mention the information we're exploring today comes from materials made available to students by the University of London.
Yes, and we really want to thank them for providing those resources. They're invaluable.
Definitely. And just a reminder for everyone listening, this deep dive is strictly for educational purposes. We're aiming to help you understand these sometimes quite complex legal ideas.
hmm
Our mission today really is to break down how a trust is properly formed, what that actually involves.
And crucially, what happens when things don't quite go to plan, when the formation is defective?
Exactly. We'll be highlighting the key cases, the core concepts you absolutely need to get your head around, especially, if exams are on the horizon.
We'll be aiming for clarity, repeating the crucial bits, making sure those main principles really stick.
So we'll start with the basics. What is Constitution? Then we'll get into what happens when it goes wrong, and finally look at some really important exceptions to the usual rules.
Sounds like a plan.
Okay, let's get started then. What exactly do we mean by the constitution of a trust? What's the core idea?
Well, at its heart, Constitution is, it's about the actual transfer of the property, getting the assets that are meant to be in the trust legally into the names of the people who are supposed to be the trustees.
Right, vesting the legal title.
Precisely. So they can then hold it for the beneficiaries according to the trust terms.
Okay, so it's about making sure the intended trustees legally own the property. But what if the person setting up the trust, the settlor, decides they're going to be the trustee themselves? Does Constitution matter then?
Ah, that's a really key distinction. Good point. If we have what's called a self-declaration of trust.
Where the settlor says, I now hold this property on trust for X.
Exactly. In that situation, the settlor already has the legal title. There's no transfer needed because they already own it.
So no property needs to move hands, legally speaking.
Correct. And because of that, the whole issue of constitution, the transfer part just doesn't come up. You never have constitution problems with a self-declaration of trust. It's just not relevant.
Understood. So Constitution is really only an issue when the plan is for someone else to act as the trustee, not the settlor themselves.
That's the scenario we're focused on, yes.
Okay, so if you do need to transfer property to someone else to be a trustee, how do you actually do it? What are the kind of practical steps, the legal rules?
Well, the rules for transferring property to trustees are actually just the general rules for transferring that type of property anyway.
Oh, right. So not specific trust rules.
No, not at all. It's the same process whether you're giving a gift, selling the property, or putting it into a trust. They're just standard property law transfer of title rules.
And I guess the specific rule depends on what kind of property we're talking about.
Exactly. It depends entirely on the asset. Land is different from shares, which is different from, say, a physical object.
Okay, let's run through some examples then. What about land? Say, a house needs to go into the trust.
Right. If it's registered land, which most land is nowadays, the transfer isn't legally complete until the trustees are registered as the new owners at the land registry.
Okay, so registration is the key step.
Absolutely. That's under Section 27 of the Land Registration Act 2002. The settlor has to fill out the correct land transfer form, give it to the trustees, and then the trustees need to apply for registration. Title only passes when that registration happens.
And what if it's that rarer beast, unregistered land?
Well, transferring unregistered land now actually triggers compulsory first registration. So again, under Sections 11 and 12 of the LRA 2002, title ultimately passes upon registration.
So registration is king for land, basically.
Pretty much. You used to be able to transfer unregistered land just by using a deed under the old Law of Property Act, 1925, Section 52(1), but that's not enough anymore. Registration is required now.
Right. What about physical things? Chattels, like jewelry or maybe some cash.
For chattels, physical goods, documents, cash, the usual way is simple physical delivery,
Just handing it over.
just handing it over to the trustees. Or you could also do it more formally, using a deed. That's a formal, written document. Needs to comply with Section 1 of the Law of Property, Miscellaneous Provisions Act, 1989.
Okay. And then there are those things you can't physically hand over, like debts someone owes you or company shares.
Chose as an action, right?
Exactly. Chose as an action. And again, the rules vary. For shares in a private company, the transfer only happens when the company officer actually enters the trustees' names into the company's share register.
So it depends on the company secretary or someone like that doing their bit.
Yes. For public company shares, it's usually handled by computerized systems like Crest.
Right. And debts. If the settlor wants the trust to receive a debt owed to them.
For a debt, you need it in writing, signed by the person transferring the debt, the assignor. That's Section 136 of the Law of Property Act, 1925. And notice usually needs to be given to the debtor, too. And one more, what if the property being put into trust is itself an interest under another trust? Like, a beneficiary wants to put their beneficial interest into a new trust.
Good one. That's an equitable interest. Transferring that also requires signed writing by the person making the transfer. That's Section 531C of the LPA 1925.
Phew, okay. Quite a few specific formalities there, depending on the asset. But good to remember their general property rules.
And also remember, none of these transfer formalities apply if it's a self-declaration of trust.
Right, because nothing needs to be transferred. Got it. You also mentioned testamentary trusts briefly, the ones set up in a will. How does Constitution work there?
With a testamentary trust, when the settlor dies, their property first passes to their executors or administrators.
The people dealing with the will.
Yes, they gather the assets, pay off any debts, and then they have the job of transferring the relevant property to the trustees named in the will to constitute the trust.
Unless the executors are the trustees?
Often they are the same people, which simplifies things. The property is already vested in them as executors, and they just start holding it as trustees once the estate administration allows.
But there's a potential snag.
Yes. The main risk is if the estate has significant debts. Debts get paid first. So the property intended for the trust might get used up paying creditors, and the trust might fail or be smaller than intended simply because the assets aren't there anymore.
Okay. So let's assume the transfer is done correctly, all the formalities are met, the trust is properly constituted. What does that mean legally? What happens next?
Once constitution is complete, it's a done deal, basically. The beneficiaries now have enforceable rights against the trustees.
And importantly.
Importantly, they can enforce the trust even if they gave nothing in return, even if they're volunteers, in legal terms.
So they didn't have to pay or provide consideration.
Correct. And the flip side is, once it's perfectly constituted, the settlor can't just change their mind and take the property back.
Even if the beneficiaries are volunteers.
Even then, a perfectly constituted trust is generally irrevocable by the settlor just because they have second thoughts.
Okay, that's clear. But now for the really crucial bit, especially for exams. What happens if someone tries to set up a trust? Tries to transfer property to trustees, but messes up the formalities? What if the Constitution is defective?
Right. This is where we get into some very important legal principles. And the starting point, the absolute cornerstone case you need to know, is Milroy v. Lord. It's from 1862.
Milroy v. Lord. Got it. What's the rule?
The fundamental rule from Milroy v. Lord is this: equity will not assist a volunteer to perfect an imperfect trust.
Okay, unpack that. Equity won't help someone who hasn't paid.
A volunteer, yes.
To fix a trust that wasn't set up properly.
Exactly. If the settlor intended to create a trust by transferring property, but failed to actually complete that transfer according to the correct legal rules for that property.
Like not getting the land registered or not using a deed for chattels when needed.
Precisely. If they fail to do that, the court generally won't step in and finish the job for them, particularly if the beneficiaries are volunteers. Equity won't perfect an imperfect gift or trust.
Why not? What's the thinking behind that?
Well, it respects the settlor's intended method. If they meant to transfer, equity won't force a different method on them. And it avoids imposing a trust obligation on someone who hasn't successfully completed the steps needed to create one.
Okay. And Milroy v. Lord had sort of two key strands to it, didn't it?
It did. First, it established that if you try to create a trust with someone else as trustee, but fail to transfer the property to them properly, the court won't just say, oh, well, we'll treat it as if you declared yourself trustee instead.
So a failed transfer trust doesn't automatically become a successful self-declaration trust.
No, the intention is different. And second, building on that, if you try to make an outright gift to someone, but you fail to transfer the property correctly.
Like trying to give shares but not completing the transfer form properly?
Yes. The court won't then say, okay, the gift failed, but will pretend the donor declared themselves a trustee of those shares for the intended recipient. That was really nailed down in a later case, Richards v. Delbridge.
Richards v. Delbridge. Okay. So failed gift doesn't become a declaration of trust either.
Correct. The courts keep those methods distinct. You choose your method, outright gift, transfer to trustees, or self-declaration, and you have to follow the rules for that method.
So the message from Milroy v. Lord is pretty strict then. Get the transfer right, follow the rules for the type of property. Otherwise, if the beneficiary is a volunteer, tough luck.
That's the general rule, yes. It's quite a stark principle.
And there's usually a but in equity.
There usually is. While Milroy v. Lord sets that strict baseline, equity has carved out several important exceptions. Situations where the court will intervene, even if the transfer wasn't technically perfect.
And these exceptions are gold dust for exam questions, I imagine.
Absolutely critical. You need to know the names of the key cases, the specific facts that triggered the exception, and crucially, why equity felt it was appropriate to depart from the strict rule in that instance.
Often seems to come down to fairness or preventing unconscionable behavior.
That's often the underlying theme, yes.
Yeah.
Preventing unfairness or unconscionability in specific circumstances.
Okay, let's work through them. What's the first major exception? You mentioned proprietary estoppel earlier.
Right, proprietary estoppel. This can step in where there's been an imperfect gift or trust, but the intended recipient, the beneficiary or dunning, has acted to their detriment, relying on the promise or assurance that they would receive the property.
So they've changed their position, relying on the flawed promise.
Exactly, relying on it to their disadvantage. Think of Dillon v. Llewellyn son builds house on father's land based on father's encouragement, but no formal transfer.
And the court made the father transfer the land.
Yes, because the son had detrimentally relied. Or Pasco v. Turner, where a woman improved a house believing her partner's assurance it was hers. The court stopped him denying her claim.
What's the absolute key element here?
Detrimental reliance. The person must have acted on the promise in a way that cost them something or put them at a disadvantage if the promise isn't kept. Gillett v. Holt is another good case showing this principle over a long course of conduct.
Okay, detrimental reliance. Makes sense. What's next? The rule in Rerose.
Yes, Rerose from 1952. This covers situations where the person trying to make the transfer, the settler or donor, has done absolutely everything in their power that they need to do to transfer the property.
Everything they need to do.
Yes, everything that only they can do. But the final step to perfect the legal transfer depends on a third party.
Like the land registry needing to register the transfer.
Exactly. Or a company needing to register a share transfer. In Rerose itself, the donor filled out the share transfer forms, signed them, gave them to the recipient. He'd done all he could do.
But the company hadn't registered the transfer yet.
Correct. The Court of Appeal said, in that situation, the gift is treated as complete inequity from the moment the donor has done everything required of him.
Even though legal title hasn't technically passed yet?
Even then, equity sees it as done, and in that gap period, before the third party acts, the donor actually holds the legal title on a constructive trust for the recipient.
So the key phrase for Rerose is?
Done everything in their power. That's the test.
Okay. Donor does their bit completely. Transfer complete in equity. Next exception. Strong v. Bird. Sounds specific.
It started very specifically, yes. Strong v. Bird, 1874. It originally dealt with debts. The situation was a creditor appoints their debtor as the executor of their will.
Right.
Under old common law, that appointment automatically canceled the debt because the executor couldn't sue themselves. Equity thought that could be unfair.
So what did equity do?
In Strong v. Bird, the stepmother had clearly shown an intention to forgive a debt owed by her stepson, Bird. This intention continued right up until her death, but she never formally released it.
But then she appointed him executor.
Yes. The court said because the intention to forgive continued and he became executor, gaining legal control over her assets, including the debt was released in equity. It perfected the intended forgiveness.
And this has been extended.
It has. It now applies not just to forgiving debts, but to perfecting any imperfect lifetime gift, as seen in Re Stewart. And it even applies if the intended recipient becomes the administrator of the estate, not just the executor, like in Re James.
So what are the absolute requirements for Strong v. Bird?
Two main things. One, the donor must have intended to make an immediate lifetime gift or forgive a debt. Two, that intention must continue unchanged until the donor's death.
And crucially,
the intended recipient must become the donor's executor or administrator. If those conditions are met, the gift is perfected when they get that legal title via the estate. No detrimental reliance needed here, interestingly.
Fascinating how that evolved. Okay, what about Re Raleigh's will trusts? You said that was a bit different.
Re Raleigh's WT from 1964 is, a bit of an outlier, though sometimes linked to Strong v. Bird. Here, someone promised in a formal agreement, a covenant, to put property into a trust later.
But they didn't actually do it while alive.
No, but by coincidence, the person who was meant to be the trustee of that promised trust later ended up becoming the executor of the person who made the promise.
And as executor, they received the very property that was supposed to go into the trust.
Exactly. They got legal title to the property, just not in the way originally planned. Buckley J. said, somewhat controversially in Obeater, that this was enough. The trust was considered constituted because the trustee ended up with the property, even if it was fortuitous and in their capacity as executor.
So the trust sort of found its property through a back door?
Kind of, yes. It's debated because it seems to conflict with some earlier cases like Re Brooks ST, which wasn't even mentioned in Re Raleigh. But the principle is, if the trustee gets the property somehow, the trust might be constituted.
Okay, a subtle one. Now, T. Toithram v. Pegorani, that sounds very specific too.
Coithram from 2000 is definitely unique. A very wealthy man, Mr. Pagorani, wanted to give his fortune to a charitable foundation he was setting up.
Which wasn't quite a proper legal entity.
No, but trust documents were drawn up, naming him and 6 others as trustees. He then had a ceremony, signed the trust deed, and declared publicly, "I give all my wealth to the foundation."
But he didn't manage to formally transfer all the assets to all 7 trustees before he died?
No, not even close.
Oh.
But the Privy Council took a very generous view. They said although his words sounded like an outright gift to the foundation, they should be interpreted as a gift on trust for the foundation's purposes.
And the key fact was?
The key was that he himself was one of the named trustees. Since he already owned the property, the moment he declared the trust, he was bound by it. His conscience was affected. He had an obligation to get the property vested in the other trustees, too.
So they treated it almost like a self-declaration of trust because he was a trustee.
Essentially, yes. A benevolent construction, as they put it. They didn't see it as perfecting an imperfect gift, but finding a valid trust based on his role as one of the trustees. Very specific facts, though.
Right. Hinges on the donor being a trustee. Okay, next exception. Donatio Mortis Causa, or DMC, deathbed gifts.
Exactly. Gifts made in contemplation of death. They're strange beasts, sort of halfway between a lifetime gift and a gift in a will.
And they don't need the usual formalities.
No, that's the point. No need for the usual lifetime transfer rules, and no need for the formalities of the Wills Act. But there are strict conditions.
Laid down in which case?
The classic statement is in Kane v. Moon from 1896. 3 things. 1, the gift must be made in contemplation of impending death. 2, it must be conditional. It only takes full effect if the donor actually dies from that cause. If they recover, they get it back.
And third?
Third, there must be delivery of the subject matter, or something representing it, showing the donor's parting with dominion or control.
What if legal title doesn't pass just by delivery, like with land?
Then the donor's personal representatives, the executors or administrators, will hold the legal title on constructive trust for the recipient, the Dundee. Cases like Sen v. Headley confirmed this applies even to land.
But the courts are quite strict about these.
Very strict. The Court of Appeal in King v. Dubray in 2015 really emphasized that the conditions must be rigorously applied because it's so easy for these claims to be abused.
Okay, so DMC, contemplation of death, conditional on death, delivery parting with dominion.
Got it. Now, the last, and perhaps most debated one, unconscionability and Pennington v. Wayne.
Ah, yes, Pennington v. Wayne from 2002. This is where things get, well, a bit fuzzy, perhaps. It potentially pushes the boundaries of Milroy v. Lord quite significantly.
What happened in the case?
An aunt, Ada, wanted to give shares in a private company to her nephew, Harold. She signed the share transfer form and gave it to her agent, Mr. Pennington, who worked for the company's auditors. She told Harold he didn't need to do anything else. So she'd signed the form but hadn't done everything she could do under Rose. She hadn't given it to Harold or the company.
Exactly. Mr. Pennington just put the form on his file and never actually delivered it for registration. So, technically the gift was imperfect.
But the court upheld it. On what grounds?
The Court of Appeal, particularly Arden LJ, held it would be unconscionable for Ada, or her estate after she died, to go back on the gift, even though she hadn't done everything necessary.
Unconscionable? That seems quite vague. What made it unconscionable?
That's the million-dollar question, isn't it? The judgment isn't perfectly clear on the precise trigger for unconscionability. They cited Choithram, but that was arguably different. Critics, like in the later case Zeidel v. Co., argued it creates uncertainty. How do you know when something crosses the line into being unconscionable if the donor hasn't done everything and there's maybe no clear detrimental reliance?
Did anyone try to explain Pennington later?
Well, Briggs J. in Curtis v. Polbrook tried to rationalize it by suggesting maybe Harold had acted to his detriment by agreeing to become a director of the company based on the promised shares, fitting it closer to estoppel. But that wasn't the court's original reasoning in Pennington.
So it's still a bit controversial.
Very much so. Some see it as a dangerous departure from certainty. Others, like Smith J. in Khan v. Mahmood, suggest it might represent a more general principle that equity can intervene based on unconscionability in failed transfers. The debate continues.
Wow, okay. So to recap then, the big rule is Milroy v. Lord. Equity won't perfect an imperfect gift or trust for a volunteer. Get the transfer right.
That's the baseline.
But then we have these crucial exceptions, which everyone listening really needs to nail down. Proprietary estoppel, detrimental reliance.
Cases like Delwyn, Pascoe, Gillette.
The rule in Rerose, donor done everything in their power.
Key phrase. Everything in their power.
The rule in Strong v. Bird, continuing intention plus done, becomes executor administrator.
Stewart, James extending it.
Raleigh's WT, trustee gets property fortuitously.
The slight odd one.
T. Choithram v. Pagarani, benevolent construction where donor is a trustee.
Very specific facts there.
Donatio mortis causa, gift in contemplation of death with conditions.
Kane v. Moon, Sen v. Headley, strict application now.
And finally, the controversial Pennington v. Wayne, unconscionability potentially perfecting the gift.
The one that causes the most debate.
It seems vital, then, for anyone studying this to not just learn the names, but really understand the facts of these cases and the reasoning behind why the exception applies in each specific scenario.
Absolutely. Why did equity step in here but not there? Understanding the nuances is key, not just rote learning the rules.
And maybe a final thought for everyone to ponder as they study.
Go on.
This idea of unconscionability from Pennington, does it actually provide a workable, clear standard for when to ignore Milroy v. Lord? Or does it just muddy the waters and create uncertainty where we need predictability?
That's the critical question, isn't it? Does it achieve fairness at the cost of certainty? Definitely something to think about further.
A perfect point to leave it on. Thank you so much for walking us through all of that. It's complex, but so important.
My pleasure.
And for everyone listening, if you want to dive even deeper, do check out the further reading materials from the University of London. Focus on those cases, the facts, the principles, and good luck with your studies.